What's going on? I've got a Judge DiSanto clip, and we have a defendant who overshares. Judge just wants some answers to some simple questions, and the defendant just wants to tell her his life story. Ah, it's kind of funny, kind of weird, kind of interesting. Let's do it. I'm Colin. We're coolin'. Let's go.
So on the record in the matter of the state of Michigan versus John Christmas II, 251330.
Very good.
I'm good, I don't know what they touched on laminated.
Can you indicate on there the adjourning the bond violation to next week as well, please?
Yeah.
Thank you. All right. Mr. Christmas, your name for the record, please.
John Christmas II.
All right, and counsel, today's the date scheduled for the, it was scheduled for an exam last week. And then, your client wanted, a different attorney. And so this court adjourned today for PCC so that your client could retain counsel and then counsel could be brought up to speed with discovery.
Excellent, Judge, and I do have the discovery now. I'm up to speed, and would the court entertain a quick oral bond modification motion?
Well, first tell me what it is we're doing with the PCC.
Oh, yes, Judge. I got my discovery, and me and the prosecutor had issued a signed order, stipulated proposed order to the court to set an exam date.
Okay. October 9th at 1:30. Right, Ellie?
Yes.
Okay. All right, and counsel, you want to address bond?
If I could, Judge, please.
All right, bond is currently $250,000, 10% bond with the following bond conditions. That is the, there's no contact with the complaining witness in this matter. That's phone contact, text message, email, social media, anything of the like, that's Ms. Mandahano. Not to return to her home in Flat Rock, not to possess or consume any alcohol or drugs unless prescribed, no access or possession of firearms or any other weapons, not to be released without a GPS tether through the Wayne County Jail.
Thank you.
You're welcome.
In relation to that, Judge, my client reports to me no history of failure to appear. If danger to the community was a concern for this client, tethering would resolve that concern, Judge. Thirdly, the police report says that the Riverview police arrested him in Southgate, not in a hot pursuit. I believe that would have been an unlawful arrest, and so he would be unlawfully detained at this moment. I would ask that he be put out on bond for that issue. To be brief, also, as I'm sure the court's aware, domestic violence is notoriously spotty when it's prosecuted by the police out of any charge. So even though my client is presumed innocent under the law anyways, specifically with a charge like that, he should be presumed innocent. But particularly concerning in this case is that the complaining victim was so drunk that night she couldn't make a police report. The next day when she's interviewed by the police, she admits her memory may be affected by drinking in the police report in writing. She admits to hitting my client with a cord and punching him in the face.
Hold on just one moment. I need the prosecutor in here, please. Or hold on, is it?
All right. Well, that's a start to a story. So the defense attorney's trying. Yeah, wild story though. He's the one in jail after getting hit with a cord. I want to know what the prosecutor's going to say. While we're waiting for the prosecutor, I do want to say, I know the audio is terrible in Judge DiSanto's courtroom. They kind of fixed it for about a day and then went right back to normal. So I don't know what's going on, but luckily the subtitles are working. So we can follow along.
And counsel, your appearance, please.
Good morning, Your Honor. Mohammed on behalf of the people.
All right, thank you. And so Mr. Quartz has made a bond reduction request. Mr. Quartz, if you can, start from the beginning again, just so Mr. Mohammed can hear all that.
So much for the application, Judge. I believe that my client, the Riverview Police say in their own report that they detained and arrested my client at a substance located in Southgate. I believe they actually put the word Southgate in their report. That's outside of their jurisdiction. It wasn't a hot pursuit case. He would have at that point been unlawfully detained without a warrant. He would then currently be unlawfully incarcerated. I would ask that at least while that issue is brief, any evidence that would follow from that investigation, I would then argue should be stricken. But while that issue is being briefed, I would ask that my client be released on a pending bond. Following that, according to the police report, she was so drunk she was unable to make a police report that night. That would, of course, go to her credibility. She admits the next day that her memory may be affected due to the drinking. She also admits in her police report that she hit my client with a sword and admits to punching him in the face. Now, one may presume that she was doing that in self-defense, but her quote is, she stated she punched the defendant in the face when he did not allow her to gather her additional items. That would indicate that my client was a victim of abuse that night. In fact, my client was making a police report with the Southgate police that night, which would give her a motive to lie and then press these charges. So for those reasons, I would ask that his bond be tethered. He has no history of failure to appear that I'm aware of. Plus, the danger to the community argument would be eliminated by tether. I'd also just like to quickly read in a one paragraph letter from his father.
No, I don't have that person here, so we're not going to allow that to be read right now. Do you have any further argument regarding bond counsel?
Gotcha.
Okay, Mr. Mohammed?
Judge, the people would object to modifying bond. I do believe it is appropriate. The defendant does pose a danger to the public. He has a previous conviction for operating while impaired, as well as a prior domestic violence charge. So based on that and the facts stated in the report, people would object.
Counsel, who was the victim on the matter from Ypsilanti in 2016?
I believe that was another woman, Your Honor.
Not this individual?
That's my understanding. I don't want to misstate it before, but that is my understanding. I wasn't on the case.
Okay, Mr. Christmas, the conviction that you have for domestic violence in Ypsilanti in 2016, who was the victim?
Well, it was an ex-girlfriend that I don't speak to anymore that has tried to message me before about
Hold
having
on,
contact her.
Sir, I don't need any extra. I just want to know who the person was. I don't need any backstory. I just need the person. It's not this current individual?
No,
What about 2017? You were charged in Riverview for domestic violence. Who was the alleged victim in that matter?
I was not charged in that matter, ma'am. That matter was dismissed because that person was
Sir?
found not credible.
Sir,
So I'm not
again,
understanding.
you're not following my instructions.
I'm just
My
not understanding. I'm
instructions
sorry.
were, who was the named alleged victim in that matter?
Her name was Haley.
Okay, so not this individual. 2021, there was an assault and battery out of Wyandotte. Who was the alleged victim in that matter?
I'm not sure, man. I was not convicted of that. I'm not really understanding.
Sir, I'm aware you weren't convicted. I'm asking who the individual was.
The alleged victim was a gentleman.
That was my question. And then I believe there was also a time that you were before this court and your grandmother was involved somewhere, correct?
The review was trying to get my grandmother to say something, but she came in, man.
Sir, excuse me, yes or no, is that correct?
I'm just not understanding your questioning for this, man. I'm sorry.
There is also another matter that your grandmother was a named, complaining witness or victim, correct?
Allegedly, ma'am, but she came into your
So
court.
yes or no? That's all I need, sir. Yes or no?
I would say no, she came to your court.
So, counsel, the court asked because there was something that involved your client's grandmother as an alleged victim, and I don't recall if that was assaultive or if that was a malicious destruction of property. I do not recall that off the top of my head, but I do recall that she was present.
If I said, I'm not sure because I wasn't there, but my understanding is, and the family is in court, that the grandma came and said that that wasn't the case of the court, but I wasn't here. So it's my understanding, per the report of the family, the grandma is in support of his release.
Is the grandmother here?
She's not here, but the mother and sister are, and I spoke personally to his father, who is a retired Detroit police officer who was paralyzed, who's not in duty, and he's told me that he will ensure his son goes up to every floor hearing.
Well, here's the concern of the court. Number one, your client is currently on probation here in this court. Secondly, this court is very familiar with your client, given the number of times that he's been charged in this matter with assaultive crimes. He has a prior domestic violence charge. And now here we are in this matter where your client is charged with assault with intent to do great bodily harm less than murder and domestic violence second offense notice. The court would also disagree that a tether would ensure the safety of the community because that just means that we can locate your client if we need to locate him. A tether doesn't do anything regarding your client's potential actions or inactions or otherwise. So based upon all of those reasons, the court's going to continue bond and conditions as it is currently ordered. The court finds your client is a danger to the community and is going to continue the bond and conditions.
Judge, would the court be inclined to refer it out for a bond recommendation report?
For DSU, I can certainly do that, but I can tell you all the times I've referred it, I don't ever get anything back from them here at this court, but I will certainly refer.
Thank you.
You're welcome. All right, we'll see everybody back next week on October 9th, and you witness and exhibit list by October 6th.
Yes, Judge, thank you.
Thank you. Have a good day.
All right, that's it. That was an interesting one. I forgot the story behind that was interesting. $250,000 bond. He's not getting that. the defense attorney, I just love it. Like, let's just get him a tether. Like, $250,000 means he did something. All right, or he's got some history. Anyways, that's it. That's all I got. Hope you guys enjoyed it. Please hit that like button, subscribe, comment, hype it, do all those fun things. You know what to do. But that's it. That's all I got. Till next time, bye.